But then you can't withhold the final paycheck. So you would have to still give them their final pay, and then if you're trying to recover, that you would file a criminal complaint or hire a collection agency or make a civil demand against the person for the return of whatever you lost. Question here.
That's interesting. We have clients that actually do dock pay, and I didn't realize that they were non-compliant. And I'm surprised that the payroll company allows them to dock pay, but that's on a separate note. But is there any recourse for somebody who damages your property? So we had a company that had trucks, and they would ding, if they got in an accident or they got a fine or something, they would ding the employee's pay. What's the...
And yeah, see, the answer is they can't ding the pay. The solution is I don't have an answer for you off the top of my head, other than to bring, is it normal wear and tear and it's something you would expect in the business anyway, in which case the employer has to eat it, or is it something that it was negligent or reckless in their behavior, in which case you might try to take a different action in order to, assuming that the person doesn't even work for you anymore. I mean, it would be really tough to sue an employee who's working for you at the same time that you're still continuing to employ them. So it may just be a risk that the employer bears.
What's the time frame that you have to pay somebody?
It varies from state to state, but you've got to pay them within a certain amount of time of the end of the pay period. And I believe that it's 10 days in New Jersey, but I'm not sure. I'm really not sure. I'd have to double check on that. But there's a specific state law. I can look it up for you later.
What is the statute of limitations of going after, say, a previous employer? You happen to be speaking to somebody, you find out all this information, and you were not exempt.
Okay, it is 2 years to bring a claim against a prior employer, or 3 years if it appears that the employer was intentionally not paying you properly. So when you bring a claim, the employer, and I may be misspeaking because I haven't looked at this in a long time. I know that if you bring a claim against somebody, the court will go back 2 years to see how long it's been going on. But your question specifically is how much time does the person have to bring the claim afterwards, and that figure I don't have at the top of my fingertips here.
What about traffic tickets and parking tickets?
Those are things I think you can say that the employee is responsible for, and non-reimbursable. But that's not a part of their pay. But again, you have to make it very clear to your workforce that I'm not going to pay for you if you broke the law doing something else. You're responsible for your own traffic tickets. You're responsible, but you shouldn't. Again, you can't net that against somebody's pay. You're just not reimbursing for them. So are you saying that your company is receiving those tickets?
Well, if it's a parking ticket, it's mine.
Mm-hmm.
Or if they blow a toll, it's mine because it's my truck.
I see. Again, question to be, that's why I said there's a lot of nuances that I don't have answers for that I'd have to go research for you. So take that with a grain of salt, what I just said, Bobby. I might have to double check on that issue. Yes, sir.
Just an hourly employee question. Can I ask one of those?
Yeah.
Okay. If someone was an hourly employee and there were expectations set on that hourly employee to do work at home, but they couldn't put in for those hours, is that a legitimate claim?
What do you mean they can't
hourly
put
employee.
in for
So
those?
say someone's a part-time employee,
Right.
they work 20 hours a week,
Right.
yet the employer demands the employee to do this other stuff.
You got to pay them for it.
Okay.
You got to pay them for it.
Somebody up here had a question, Rachel, is it you? She works for schools.
Could you
Sure.
Hi. Could you speak a little bit to the difference between W-2 and 1099, and also if a client, like if one of our clients wants to pay us via a 1099,
Mm-hmm.
are there any ramifications for that, or can we just be taking payment via 1099 any old time?
Well, as a vendor, you would be paid as a 1099 vendor because it has to do with tax reporting. And so a W-2 means that when I report the payments that I'm making to this person, that they are an employee of mine and that I'm going to be taking out contributions for, I'm going to be taking out withholding, I'm going to be taking out contributions for Social Security, for an unemployment contribution to the state. I may be making payments for benefits for that person, a 401k plan, all those different withholdings that are made in the course of an employment relationship. And that's a tax document that you're reporting to the government. This is how much we paid them, these are the deductions that we made, And this is how it's based on the employment relationship. The 1099, again, I'm not a tax attorney or an accountant, but my understanding is that the 1099 is what you would use with your vendors who are not your employees. Okay, and again, going back to the difference between who's a vendor versus an employee, that is assessed on the basis of how the relationship develops and the exercise of control over that relationship. Sure, question from Chris.
As the facilitator here, you're doing great.
Yep.
Loving it, but I'm concerned about time. How are we doing time-wise?
We are in good shape. We are just about, let's see, we're 2/3 of the way through.
Okay, just to be careful with all the questions.
Sure.
Thank you.
Sure.
Sorry, so if someone wanted to pay you, as if you were doing legal services for them, and if someone wanted to pay you a 1099,
Right.
normally you, that's no
That's
prob-
appropriate.
It's appropriate,
Yeah.
thanks.
Okay, any other questions on wage and hour and how much we have to pay people? The bottom line is, you have to pay people for every hour they work for you.
I have a question.
Sure.
This is a stickler for me, and you and I have discussed this offline. So you have an hourly employee, let's say, and you have a weekly or a monthly staff meeting. Can you ask an hourly employee to come in for a 1-hour meeting?
And the answer is yes. And the
Okay, so
and
I'm
even if
wrong.
it's a 15-minute meeting, you can have them come in, except in New Jersey, you have to pay 1 full hour's pay. If you're bringing somebody in, and they're not normally scheduled for that day, but you're bringing in for the meeting, you got to pay them a full hour for that time that they're there. Then there is an exception. The exception is unless they've already worked the number of hours that they expect to work that day. But in your case, what you're talking about is a one-off. You have to come in just for this one meeting. You've got to pay them at least an hour. If the meeting goes over an hour, you're paying them for the entire time that they're with you, obviously. There are a lot of other areas where we have to be aware of what we owe our employees. Training time. If we require them to undergo certain types of training, our non-exempt employees would be entitled to pay for that time. Travel time in certain instances, and again, it would take me too long to go through it all, but be aware that if you have them traveling on business for you, that may be compensable. Time worked from home, time checking their emails, if they're on email with you. Now again, the important thing is to tell them, you need either A, don't check your emails after work hours. I don't want to hear from you. I don't want you to be engaged with me. Or if you do, then you need to report that as time worked for me. So that's tough. Dune?
Social events?
It depends. That's a good question. And the answer is, what is the subtle expectation of the boss that they be there? Are they perceiving it as this is social and completely voluntary and nobody cares if I go or not? Or do they feel, and remember there's always a power relationship between the boss and the subordinate, and so there is always going to be some sense of an obligation on their part, even if you try to tell them there is no obligation. But if they go and it's a mandatory event that they be there, yes. If it's the company picnic, come if you want to come, don't come if you don't want to come, that you can say was not a work day. Okay, I'm going to switch gears just a little bit then. Oops, wrong one. Let's go to this one. We're going to talk a little bit about harassment, another misconception. It is okay to banter with your employees about their protected characteristics, race, age, religion, gender, so long as they think it's funny too. Okay? Let's ask a certain chef from the South whose entire empire crumbled last year about how those employees felt about that bantering that went on. You know, it is not funny. And people will laugh and they'll joke with you because you're their boss, okay? And you're the one who's controlling the paycheck. Just remember that everything you say as a boss, as a supervisor, can and will be used against you, okay? If you make jokes about the age of your employees, you say things like, we got a lot of dinosaurs around here, or, man, I really want to get some new blood and I need some younger people in my workforce. If you make those statements and then comes time to select people to terminate or to performance manage, and those are the people that you select, that's what's going to stick in their minds. You never liked the older workers, you're really trying to select younger people, you make dumb blonde jokes in the workplace, and then you happen to have some blonde women working for you. Those who happen to be very successful and very smart and very articulate. But then if that person is selected for some type of performance management or discipline or termination, that person will remember those remarks that you made. And that is considered direct evidence of discrimination. So you just have to be very, very careful. There was one case I remember that I read about a couple years ago where a man, it was an African-American man who worked for a company, and he would walk down the hall with his white colleagues, and the boss would come down and say, "Hey, John, hey, Bill, yo, homie." Okay? Maybe he thought he was funny, maybe he thought that he was relating to somebody who was different than he, but it wasn't appreciated. And obviously it didn't, it turned into a lawsuit against the company because he was treating that person differently on the basis of his race, and that's not how you conduct yourself in the workplace. The easiest thing to think about when it comes to unlawful harassment is that don't treat people differently on the basis of these protected characteristics, because what you're doing is you're making fun of who they are. You're making fun of things about themselves that they just can't change. You can make fun of my jacket, you can make fun of my hairstyle, you can make fun of some other types of things that I can change about myself. But don't make fun of who I am, because I can't change it. That's just who I am, that is my essence. And that's the kind of thing that you should just leave alone when it comes to dealing with people in the workplace. Another misconception: so long as you treat everybody identically, you will not violate the anti-discrimination laws. Okay, untrue. The fact of the matter is that there are people in the workplace who are entitled to differential treatment depending on religious observance, depending upon physical or mental condition. So you need to know what situation your employees may be in at any given time, because you might have an obligation to accommodate that person on the basis of whatever his or her condition. Others might be entitled to protection for their absences. In fact, in New Jersey, we have two very new laws. One, the domestic violence law that was passed last year, where employers must give protected absences to people who are the victims of domestic violence to attend to, whether it's filing a police report, medical attention, finding new housing, whatever the circumstances may be. That person is entitled to miss work but not be disciplined for those absences because he or she needs to attend to those issues. The second law that hasn't been signed by the governor yet, but we expect it to be very soon, is the new pregnancy discrimination law. And that law will now entitle women, it's funny, it's women affected by pregnancy. I'm not sure why they chose that particular term, but in any event, women who are affected by pregnancy are entitled to accommodation in the workplace as well, based on the medical condition and whatever the advice of their physician is. So you need to know what is going on with your employees. Now, it is always okay to ask your employees, is there something going on that is preventing you from doing your job? Or is there something going on that is preventing you from getting to work on time? What you should not do is the reverse. You shouldn't make assumptions about somebody's condition and then assume that that condition is impacting their work performance or is impacting their ability to attend. You always want to ask open-ended questions, but it's okay to ask those open-ended questions and draw that information out of the person so that then you can make an informed decision on what steps to follow next to make sure that you have protected that person's rights, protected your own rights, and protected the company. So it's important as to how you conduct those conversations instead of asking about a particular health condition or a particular mental circumstance, et cetera. Just be open-ended. What's going on? Your work performance is slipping. Why is that?